to everyone that has joined us today. We're very excited for our guest speakers that we have on the line. So you'll see that we do have Natalie from Spence Attorneys. And one of the reasons why we have decided to do this is we get a lot of questions from you, our customers, around POPI in the B2B space. So obviously there's POPI in the consumer area, and there's, areas of non-clarity. There's the POPI consent clause that we've had to add into all of our credit applications. So we've invited Natalie and her team to come and talk to us about what do we need to know about POPI with regards to the areas we deal with in the credit space, in the B2B space. Even when dealing with sole proprietors on a business level, what do we need to know? Where do we need to make sure we've ticked our boxes to say that we're compliant with the POPI Act? And what would be the consequences should we not comply? So thank you so much to Natalie. Natalie, just to introduce you, we also have Martin on the line, who's our head credit executive, as well as all of our Trade Shield customers. So, and there may even be some that are not Trade Shield customers. So welcome to everyone on the line. Did I lose Natalie?
Thank you.
Oh, thank you. There we go. Can you hear us now? Natalie, you are on mute. Oh, we lost her already. Maybe we scared her away. I mean, I tend to, apparently I am quite scary, even though I'm only like 5 feet tall.
And that was the POPI Act in business. Thank you,
and not just the POPI Act. No, there we go.
Right. No, okay. Sorry about that. We were just having some technical issues outside. My camera doesn't seem to be working, but I don't think you're missing out on much.
No problem at all. I will smile on your behalf. Or if you have one of those little emojis, sometimes if I can't use my camera, I use an emoji just for fun. But no problem. We're really excited to hear what you have to say, and looking forward to your presentation. So take us away.
Okay, wonderful. Thank you very much. I'm going to share my screen with all of you. So a very big welcome to everybody. My name is Natalie McDonald Spence, and I am on the line from Cape Town. It is extremely hot at the moment, which normally would be fantastic unless you are 8.5 months pregnant like me. So there is obviously a wide variety of people attending today. Some people have got vast experience in POPI compliance within their organizations, and some people have probably got limited to no experience at all. And so it's I've prepared this presentation to balance that between everybody. So I hope that you'll find it informative. You are welcome to ask questions throughout. I will also allow for some time at the end for you to ask any questions. But let's get going. And everyone can hear me fine?
Yes, we can.
Yes, we can.
All right.
We can.
Okay, so just a little bit about me. My firm is based in Pinelands. I am also a solicitor of England and Wales, and I practice primarily in South Africa. I do have a lot of clients in the UK, commercial and individuals. We work largely with corporate and commercial clients in the privacy sector space, corporate and commercial contracts, general compliance, as well as other things like conveyancing, deceased estates administration. But POPI compliance is one of my personal favorites to talk about, just because it is it's one of those topics that for many years, because it took so long, there was always the threat of POPI. You might have remembered before it was actually officially enacted. It's a lot of organizations weren't sure, when do we start complying? If you are still asking that question, you are a couple of years behind. We should have been complying already for the last 4 years. I'm not going to be going into principles of things like GDPR to the extent that you've got foreign clients within the EU. Today is going to be focusing primarily on POPI and in the context of business-to-business credit applications. I will start off with just going through a basic overview of what POPI compliance is about. Just to get a general indication, what lines of business is everybody in here?
Well, I think I should answer that for them, Natalie, that there's a wide spectrum from post-consumer goods to logistics, to translate, and so
agriculture, steel. Yeah,
you've got the
I see
whole
them popping.
yeah.
I see you've got telematics sales, manufacturing. Yeah, quite a few from manufacturing. So yeah, a wide variety, engineering, consumables. We've got tire companies, logistics companies, stationery suppliers. See, they popping all that into the chat. So thanks, everyone.
All right. So a wide variety of people. Do all of you receive emails every day? You don't have to answer that.
Absolutely. I know I just today received at least 100.
Yes. Okay. And right now we are on a Teams meeting. Okay. And I can see all of your names. Every day you are getting emails from people. You are probably processing applications every day. You are getting purchase details. When people pay with their card, you are getting their card information. You are getting their bank details. All of this is information. I have yet to come across anybody in the business context who can clearly say POPI does not apply to them. POPI applies to all of us. Okay. And the information that we handle, it's very sensitive, especially in the age that we live in with artificial intelligence, cybersecurity. You will be aware of numerous incidents in the news of cyber security incidents. I've dealt with scenarios where clients have had email accounts hacked and their databases have been exposed. I've had clients across wide ranges of industries, service providers in email hosting, internet hosting, normal consumer service providers, and them deal with very sensitive data. Nowadays, hello?
Oh, sorry, I was just muting. Sometimes it just pops out. I fixed it for you. Sorry, continue.
So nowadays, information is obviously it's vitally important to protect it because it is a massive risk to your business. And I don't want to say that you shouldn't underestimate that. I want to say that you shouldn't underestimate the importance of putting safeguards in your business. I very rarely come across a client that says to me, Natalie, I am POPI compliant. When you start asking questions and we start doing POPI audits and we start doing privacy assessments, we find many gaps and areas that are not sufficient enough for data security and protection of personal information. You've been entrusted to safeguard this information. And if you do not safeguard it, you can face fines and penalties and possible personal liability if you are the information officer of your business. Okay. So POPI regulates how businesses process personal data. It applies to individuals and juristic persons. Okay, so it doesn't just apply, it's not like the Consumer Protection Act where it only applies to a certain industry of consumers, for example. It applies to all persons. Okay. I will take you through the act now as well. So personal information is anything that's identifiable, living, natural persons. Okay. With banks, for example, they've now adopted voice recognition, thumbprint recognition, etc. That's all identifiable information. Okay, so examples of personal information, I'm not going to go through too much of it, but in the context that you will probably deal with is people's identity number, juristic person's details, director's details, contact numbers, location information, private and confidential correspondence. So then again, you are getting emails every day. It is somebody's correspondence and personal information. Okay, who is a responsible party? Okay, when you are receiving an email, okay, your organization is a responsible party. Okay, because you are receiving personal information or data over email. Okay, when you are receiving a WhatsApp, okay, you are a responsible party. And that means that your staff who've got access to all of that, they are, by extension of you as the employer, they are also responsible under you to make sure that there are safeguards with personal information. I'm going to ask another silent question in your organization. You don't have to answer me, but how many of you have staff that are allowed to use browse various sites during the day on their personal work, on their work laptops?
Absolutely. Even I can say that we can browse certain sites, any sites other than, I suppose, like Facebook or one of those.
Okay, so inherently there's always a risk that your data and security on your computer servers and your laptops can be exposed. If you visit an unsecure website, okay, the information that you are transmitting on that unsecure website is potentially exposed. Again, another silent question: how many of you have worked on a work laptop or on your personal laptop for work purposes in a coffee shop?
Absolutely.
Using the coffee shop's Wi-Fi.
Absolutely.
Okay, so there is already another risk, a massive risk for the data that you have got in your possession. Okay, and when you receive emails, obviously we can spend hours going into this about cybersecurity itself. Yeah, absolutely, it's a cyber risk, but cyber risks and POPI risks are very closely linked, because obviously if your cybersecurity safeguards aren't sound within your business, you are exposing the data that is in your business's possession and control to third parties. Okay, and a prime example is with Discem. Discem was recently fined. You can go and have a look on the information regulator's website. One of the things that Discem was fined for was having inadequate safeguards with weak email passwords. Okay, now if you've got an organization with weak security safeguards such as passwords, you can get fined for that, because you are handling data and you are not implementing measures to keep it safe. So naturally, if you are going into a coffee shop to work on a work laptop or to use the public Wi-Fi with data, it's not necessarily secure Wi-Fi provider that you're using. So anything that you are transmitting over that Wi-Fi is potentially exposed to third parties. Okay. That is why I'll often hear from clients that say to me, Natalie, I don't understand. I had money stolen from my account, or I had my card used fraudulently. And it turns out that they had made payments on their laptop using their, let's say, Google Wallet or their Samsung Pay or whatever the case may be, using the Wi-Fi. And that information was not secure over the Wi-Fi. It's an unsecure network. And someone was able to procure that data and use it unlawfully. Okay. Other things to consider: when you work in a coffee shop, let's pretend you're not using the Wi-Fi. You're working on your business work. You're dealing with customer data or whatever it is on your laptop. Do you think that is POPI compliant and you're not using the Wi-Fi?
I'm going to take a wild stab and say yes.
Okay, it depends. Okay, so you've heard of shoulder surfing. You could have somebody next to you who can see exactly what's going on your screen. You might not be aware of it, but you may inadvertently expose information. If you are having a business meeting at a coffee shop, okay, you might potentially be discussing something that contains personal and identifiable information pertaining to a company or an individual, okay? And of course, people can hear it, okay? It's yeah, someone says we've got security screens on our laptops. Fantastic. Okay, all methods of protection of the data. But again, conversations, you've got to be very careful and aware nowadays, because you're talking on your phone, you might be working and talking on your laptop in a business meeting. Everything that you are talking about, you've got to be aware that you might possibly be contravening POPI. Now you might be saying, but Natalie, how am I supposed to function in this day and age where we have business meetings in coffee shops, where we have it all over? Well, it depends. You've got to do risk assessments and determine what is within your company policies, address company policies. For example, when I work on company employee policies for staff within organizations, it is an express requirement that staff are not allowed to use Wi-Fi in public coffee shops when working on work laptops, or alternatively, they can use their own VPNs, or they can use their own hotspots, provided it is secure. Okay, so company policies are essential to implement, and a wide variety of people say to me, but Natalie, I can do it later. I don't want to spend the money now on drawing up a large policy. I understand policies are scary. They are voluminous and it takes time. And obviously, at the end of the day, you don't want a Dis-Chem moment getting a huge fine, okay? As well as other organizations that are starting to now get fines. We're starting to see the information regulator get teeth. So now more than ever, there is an essential requirement to ensure compliance across your organization, especially with the level of data that you are dealing with. For those of you that are part of the Credit Bureau Association, I don't know if there would be anybody here, but you would also need to comply with your code of conduct in terms of personal information processing. Okay, all right. So why is this POPI compliance necessary? I've already spoken about it. There is the constitutional right to privacy, as well as it balances the right of privacy against other rights, such as the right of access to information. You'll find that right of access to information contained in the Promotion of Access to Information Act. Okay, so for those of you that are involved in your organizations from a compliance level, you should know that you should have a PIA manual available on your websites, as well as a hard copy in your organization available. So if the information regulator comes for an inspection, they will want to see that you've got your PIA manual available. Okay. It also regulates the manner in which personal information may be processed. Okay. So here's are all just simple examples. Okay. If you are aware of a data breach, okay, you are obliged to inform the information regulator. Okay. That's one thing that Dis-Chem, for example, was found in the enforcement notice, that they did not have a compliance framework. Okay. They did not report a potential data breach, etc. And look, we might say, oh, okay, Dis-Chem is the bad guy here, or Dis-Chem didn't do their proper due diligence. Now, I can assure you, Dis-Chem is not the only one. Like I said, almost every business that has come to me has had similar non-compliance. So it's just that Dis-Chem had an inspection, okay, and there was the data breach that they became aware of. And of course, it was not reported, and they were served with a fine. Okay. So although it was enacted in 2013, it's been effective since 1st of July 2021. So by now you should have an information officer within your business. Last year you should have submitted an information return to the information regulator. Okay. The POPI Act governs the collection, processing, storage, and sharing of personal information. Okay, so not only do things like receiving emails, is that affected by POPI, but actually storage of personal information, because the Act says we are only allowed to store information for as long as is strictly necessary. Now, I'm an attorney. By law, I am required to retain data, personal information, and files for 7 years from the date of working on a matter. Okay, so by law, I have to keep it for that long. Your business might not have that obligation to keep it for that long. If you are an accountable institution for whatever reason, you will know that under FEIC, under the Financial Intelligence Act, many organizations that previously weren't an accountable institution now are an accountable institution. So there are requirements to retain records for 5 years under statutes. And of course, if you are a credit provider, you are obliged under the National Credit Act to also retain data. Okay. So when you store that data, it's not just about storing it, it's about storing it securely. Okay. And you might say, but Natalie, so I'll share a personal story myself. Obviously, the longer I am in operation, I've got to keep records for 7 years. We work mainly on an electronic basis. We are in the process of moving from hard copy to electronic. Of course, that uses a lot of data. So I've got to make sure that where all this data is stored is absolutely secure. Do regular POPI audits within my business, and do regular training with staff, because obviously the bigger the organization is, the higher the compliance risk. And that is what I find with small businesses, especially as they scale to become larger businesses. The compliance risk and burden becomes immense because all of a sudden you're not just working with 5 or 6 staff, but you could be working with dozens or hundreds of staff who all deal with personal information. So that training aspect is an obligation under the Act for responsible data handling. Okay. All of you ideally with websites should have your privacy policies. Okay. Your privacy policy should state how information is stored and processed. Okay. I'm not going to go into it for long. Okay. But ultimately, all of your businesses should have a privacy policy. Okay. And then your PIA manual will set out how persons can access information. Okay. And there are limitations on what information can be accessed. But it sets out in your PIA manual specifically how that process is done. Okay. So the Act applies to natural and juristic persons. Okay. So businesses must protect the data of other businesses as well. Okay. Not just in persons. So in the context of credit applications, whenever you receive a credit application for trade finance or it includes financial statements, it could be credit history and payment behavior that you are receiving. All of that needs to be adequately safeguarded under the Act. Okay. Companies need to ensure that they only collect necessary information when assessing the credit worthiness. So if I go quickly to our, give me just a second, the conditions for processing of information lawfully. Okay. Your organization needs to implement measures to ensure compliance with POPI regulations. So just out of interest, I'm going to open this up to the floor because I think it's great to interact. Otherwise, you're going to get bored by my voice for the next half an hour. In your organization, what measures have you that you are aware of? What have you already implemented to ensure compliance with POPI?
Sure. Not that I know any of them, Asha. So you can feel free to ask questions. I can say from a Trade Shield's perspective, while we're waiting for anybody else to raise a question, is part of their credit application process, which is an automated process. We have created a mandatory POPI consent clause that is directly linked to our customers and their POPI compliance information on their websites, or if they've got documents, we include it for them there so that a customer can't complete a credit application without providing POPI consent. So that's how we as Trade Shield help our customers. But if anybody else wants to add in how they in their businesses also then work around POPI.
Okay, some people are saying it's part of their credit applications. Yes, so that's when
That's
you
us.
work. Yes, that's part of your application forms. And tell me, do we have any, perhaps let's say smaller businesses, do we have anyone here from HR or someone who has HR as part of their business? Okay.
Yeah, I see that they said update staff ongoing with training.
Okay, so data that you use in your organization is not just about client data, but also your employee data. Okay. So the reason I asked for any HR people is that obviously companies have a duty to safeguard employee information. Okay. So it's not just compliance with the parties that you're dealing with being clients or other businesses. It's also internal compliance with how you handle the information within your own organization. Okay. So when I say in terms of accountability, I also mean relating to internal compliance and accountability. Okay. So your measures that you need to ensure that there's regular POPI compliance would be perhaps regular changing of passwords, having minimum password standards within your organization, having limitations on how laptops can be used. One of my clients who is in the web hosting space, dealing with very sensitive data, we did an audit, a POPI audit on them, and we recommended that they implement having no private laptops, having strictly company laptops, just so that they could be adequately used. For those that are working in the financial services industry, There's also compliance under phase, for example, with treating customers fairly. That also involves handling of their data. It's incredible the extent of cybersecurity that is implemented in those organizations. Regular audits, on-the-spot training with staff, ensuring that, let's say, personal WhatsApps aren't used, ensuring that that data is securely held. And there are, I can spend hours on speaking about how we can implement this, but this is supposed to be thought-provoking. So what are the internal measures that you've got? We start with the basics, of course, your compliance your POPI compliance manual for the company, your employee awareness webinars or training sessions, your cybersecurity measures that you've got internally, as well as things like your privacy policies, and ensuring that you've got regular checks on your organization's data. Okay. There's also a limitation on processing. It needs to be fair, lawful, and justified. So selling people's information unlawfully, okay, if it's not in the context of your business and you've not been given consent, that naturally would not be fair, lawful, or justified. Okay. The collection and use of personal information must be for a well-defined, legitimate purpose. Okay. It cannot be processed for secondary purpose unless they align with the original intent. Okay. Now, when you use third parties, I'll address the HR question in a second, but when you deal with third parties, let's say you use contractors to outsource your information. Now, people often forget this, and this is probably a big nugget for those of you who are looking into POPI compliance for your business. The use of external service providers, and let's say you save everything on the cloud, or you've got some service provider that hosts you, etc. It is your responsibility to make sure that they have adequate measures to safeguard the information. You can't just say, okay, I'm going to contract Bob down the road to help store my organization's information. You can't just leave it at that. You've got to sit with Bob and say, we're going to have an agreement. And in that agreement, we need to agree on how the information that we give you is going to be regulated and safeguarded. Okay. So your use of third-party service providers also needs to fall into the scope of ensuring that you've got measures to implement with POPI. Okay, so as you can see, it's quite wide, and this is why there's value in a POPI audit, because it helps you to see things that you've missed. Okay, because we're all human. There's often times where we think that we are okay. We think that we I think I can liken it to driving a car. You think you're going within the speed limit. Oops, you're 64, or oops, you've missed a sign. It happens. Okay, there's human error that falls in, or the law changes, regulations change, and you might not be aware of your obligations in an organization. That's why POPI audits are great, a really great tool for risk management within your organization. Okay. Now, your information needs to be kept up to date, accurate, and complete. Okay. Now, usually clauses along these lines we include in our privacy policies or client take-on forms. Okay. We ask the client to update us should their details change. Okay. But also at the same time, every time we deal with a client, we ask them to confirm their details. All right. Organizations also need to inform their clients how the data is being collected, processed, and used. Okay. So you need to you can't in your application forms not provide for third parties that are using the data. It would go along the lines of, from time to time, we make use of third-party service providers to deliver our services to you. You expressly consent to the use of our service providers. Our obligation as the responsible party is to ensure that this party ensures safeguards within their business. You expressly authorize us to do so. Okay. Personal information needs to be safeguarded against loss, unauthorized access, changes, misuse, and destruction. Okay. Now, this is also where employee training is absolutely essential, because one of the biggest risks when it comes to cybersecurity is obviously phishing. The second you get an email that looks very legitimate, the second you click on this link, you've actually opened a backdoor for a hacker to get into your organization, and they've all of a sudden within seconds have got access to all your information within your server. Okay. Data can be destroyed. Sometimes it's malicious. It could be anti-competitive. Data gets destroyed. It could be held to ransom. Okay, you might find that that information is changed. Okay, and that also exposes the client. Okay, so for example, let me give an example. One of my clients updated the information with a financial services provider and was in the process of a very acrimonious divorce. Asked the service provider to update the information, and the service provider did not. And as a result, the service provider, then the financial services provider, sent very delicate financial information to the other spouse, which was then used in divorce proceedings, which the other party did not want them to immediately have. Okay, I'm not going to go into the merits of those kinds of things, but that's just a classic example of why acting on a client request to update data is important. Okay, because when you don't act in terms of law, you incur civil liability. Okay. And obviously they've got a right under the act. It's their information to be updated. Okay. People need to be allowed to access, amend, correct, and delete their personal information when necessary. But of course, in the context of credit applications that you possibly work with, that information is limited by law under the National Credit Act. And of course, usually the credit bureaus have their own processes. An individual can apply to correct or delete information on a credit bureau, but obviously subject to the limitations of law. Okay. Are there any? There was just a question. Let me just double check what that question was. Oh, okay. No, not this. Okay. Sorry, what was that question?
So there's two. So it says regular POPI or POPIA training and tests. Okay, so maybe we can also just touch on the difference between POPI and POPIA. And then there was a question with regards to HR, how are CVs handled that are sent through?
All right. Okay, so when CVs are sent through, obviously you'll get the norm of people just sending their CVs through via email. We get it through every single day. Now, the correct way of dealing with it is perhaps, let's say, having an online application process. Okay, and before a person submits their CV, they should consent to the processing of their data and information. That POPI consent should be contained in the formal process. Of course, you can have your privacy policy on your website stating how emails received by the organization are dealt with. Okay. And then automatically, then the data should be dealt with according to your privacy policy. It's obviously a bit of a gray area when people just send it, but they are giving their data over email. Just having your privacy policies updated to provide for circumstances like any information that's transmitted to you. By sending an email, they expressly consent to the processing and storage of their data. But I wouldn't consider if you've got the capabilities of receiving CVs online, that would be the acceptable platform. If you've got an email, you can tell the person, please resubmit it over the websites at this formal link. But that is a very good question. Yes.
Yeah.
I think that one of the biggest exposures that we have as a credit fraternity is when we use third-party vendors in the form of we outsource certain of the functionalities, the collection functionality or our invoicing functionality. There's a lot of those outside in the market, and there's a lot of these BPOs that help businesses manage those processes. And I think there in that lies a massive possible exposure for the POPI Act to be broken. If your information is not protected with that specific service provider. So I think our guys must make very sure if they use that there are very specific clauses and things in place that is going to safeguard them and that they've got the permission. Because I'm sure you have to have the permission of your client if you are going to use a third party, like we do in the normal credit application. We say, you hereby give us permission to do a credit check on you. And that means we're going to share your information with a credit bureau. And the credit bureaus, as you just now said, is subjected to a very different set of rules. However, a collection agent is a different set of animals again. And they are not guided by the same rules as what the credit bureaus are. And there are a lot of them, and a lot of them are not huge, reputable collection agents. They are small companies. There's a guy that has been a credit manager for years and all of a sudden now starts doing collections. Some of people in your industry, in the attorney industry, does that as a sideline. So they do legal work and they do collections work. How and where do we find ourselves exposed, and how can we protect ourselves in that book?
Yeah, look, I mean, again, something like that, a POPI audit would really be great. Regular POPI audits, and also making sure, when you do take on third-party service providers, or finding out where the data that you're getting it, of course, making sure that you are acquiring it lawfully. So things like a POPI audit would be appropriate there. But again, it's such a vast field of compliance. Some organizations have numerous individuals dedicated to ensuring POPI compliance due to the level and amount of information that they are working with. I mean, things you'll find in many organizations, simulated cybersecurity exercises are frequently done to test whether employees, have been trained not to open certain emails, not to engage in certain practices. On the spot checks, it's a way to prevent future incidents. So yeah, so it is a big minefield. And again, it's I don't want you to walk away with this going, oh my gosh, it's so much to comply with. Because again, if you install a framework within your business, with how you deal with it, it's one of the fields I absolutely highly recommend engaging a professional with, because obviously with the information regulator now stepping up and doing more regular enforcements and inspections, it's not a matter of it's a matter of when in future, especially with cybersecurity becoming more and more vulnerable within organizations. There was another question. I'm sorry, I cannot see the questions online for some reason.
No, that's okay. So I can let you know. So we've answered the HR question. Then it said the fine print in my medical aid stated stated I may not be covered if I do not agree to the data used for their marketing and research. Is that allowed?
Okay, that sounds like opinion work. Yeah, it's remember, any information that you any forms that a consumer might sign, it's always subject to the Consumer Protection Act to the extent you are a consumer. Okay. It also, of course, the health industry is obviously governed by their own code of conduct. So you'll find often I'm not going to speculate on this one, especially if we've got a discovery person in the room. But if you are of the view that, let me give another more practical example. It might be impossible for a third party to contract with you unless they have access to your data. So in the context of medical service providers, they might want to decide whether to cover you with information. If you don't consent to the use of your information, they're unable to perform their side of doing a risk assessment on you. In which case, if they don't have access to your data, they might just then give you cover, take your premium every month, but then it turns out you didn't disclose everything or they didn't have access to it, in which case they wouldn't have covered you at the get-go, and as a result, you don't get cover. So that's a typical example in any financial institution or medical aid. If you don't disclose, they probably won't cover. They might take your premium, but they'll just refund you your premiums because the heart of a lot of privacy use is actually in contract. Okay, whenever you use a website, for example, you are actually contracting with the owner of that website in terms of their privacy policy, in terms of use, as to how you use their website. When you are working with another organization and they've got their disclaimers and email disclaimers, usually that's in terms of contract. So when you work with a financial institution or medical aid, etc., you obviously, your first start with that organization is a contract. Okay. So naturally in law, when you breach a contract, be it by non-disclosure, that's material misrepresentation, it invalidates the contract or has the potential to invalidate it. When you deal with a party and you're not aware of your rights and obligations, there's a limit to how much in law you can say you did not have knowledge. That is why we usually recommend, when you have a website, have a pop-up, the first thing that comes up when someone uses your website, relating to how they use your website. Okay, and there was another question.
So it was somebody commenting on the previous question, but one of the things they did bring up, which I thought was interesting, how does POPI and cookies work in tandem? Like, is there a correlation between accepting somebody's cookies and the POPI Act?
Well, absolutely. It's usually, it would be under your terms of use and cookie policy on your website. Okay, you cannot just, and it also depends where the website is originates from, in which jurisdiction. But in the South African context, obviously, if the cookies collect and store information, that would you'd need to agree to that, in terms of in what they store about you, your browsing habits, etc. For our browsers, for example, we don't allow automatic. We don't allow for cookies to automatically store information. We have to be asked. Having secure browsers and antivirus software and online software is crucial to ensure that measure of protection. But yeah, you would need consent for cookies to store data, and that's part of what you'll often find when you go onto websites. There's a pop-up asking for consent to store, and you might just click, not really knowing what you're actually reading.
Absolutely. Absolutely. I said the only cookies I like are these kinds. I'm joking. Okay, so then I see there's also another question that said, do you prohibit the user from accessing the website if they do not accept your cookies?
No, not ordinarily, but certain functionalities might not work. And obviously they can't store your information if you haven't accepted it.
Absolutely. And in saying that, the same thing
Yes.
would apply, in terms of if somebody doesn't accept your POPI compliance or you're giving you consent, then how do you send them an email? How do you invoice that person without, having consent to use that information? So it's very vital. It's more than just, can I keep your name on my system?
Yeah, look with the terms of use on your websites and your privacy policy. We usually provide that if the user does not consent to it being used in the following manner, they should stop immediately using the website.
Perfect. Excellent. Okay, I think there are no further questions right now if you want to continue.
All right, I'll go through quickly. I see time-wise we are doing exceptionally well with time. So, all right, so just some key compliance principles. It's just informing clients, okay, explain why the data is being collected. So usually put that on your website or whatever method it is that you are contracting with them, on your forms, etc. Explain what is relevant for the credit applications, only what's necessary. So, for example, collecting information that is not necessary, you would be contravening POPI by doing that. Okay, you might want to try and explore marketing habits of people. You can't make that compulsory for people to give if unless it's strictly necessary for you to perform your function. Okay. Obtain explicit consent, ensuring clients agree to the data processing. Okay. And now again, I find the Consumer Protection Act also goes hand in hand with this as well. Just depending on what service you are providing. So just always be aware who your client is and that you are complying not just with POPI, but you're also complying with the National Credit Act, as well as the Consumer Protection Act when you are dealing with clients, as well as, of course, the Electronic Communications and Transactions Act. And for those of you in other industries like financial intelligence, etc., if you're in financial services, you'll obviously need to comply with that relevant legislation as well. So we use that as part of a mapping exercise, a POPI compliance mapping exercise, to see what industry you work in, what is the affected legislation that affects your work, and what specifically do you need to comply with? Because obviously, for those of you who are working with steelworks, you are going to be in a very different industry to someone working in the stationery supplier field. Whereas, for example, the work that I do as a law firm, very different sets of legislation that applies. So do not just say, the most common thing that I hear from somebody say, especially startups, I do understand it's you're on a budget, you don't have a lot to spend. But the most common thing I hear people say, oh, it's fine, I'll just download a template online. It's like saying, let me take an outfit I buy online and see if it fits for my body. Okay. I'm just going to, let's say you buy something on Temu. Okay. Now, something that some of my friends have found, that a size 6 on Temu is not a South African size 6. Okay. So they've bought it only to find it does not fit, okay, after the fact. And now they can't return it. Okay. Do not take something and assume it will fit your organization. Okay. So information that you don't require in your business, it's not an asset. It is a liability, because you are actually contravening the act by retaining and storing information that is not strictly needed. Okay. You need to have a robust data protection policy within your company, of course. Clients as well. I've advised some of my clients to seek financial advice pertaining to cybersecurity insurance to the extent that they work with things like funds. Because, of course, if there is a data incident, remember, you are the responsible party. Okay? When you are a service provider and you are responsible for something and you fail in that responsibility, okay, the law of derelict applies. Okay, what was your duty of care to your client? Okay, and under the Act, it's clear to implement safeguards and internal control measures, okay, within your organization. If you fail in that duty, that's where liability can occur. We saw that ENS case, for example, that was quite a scary case for us lawyers, okay, where that was the Haywarden versus ENS case, where a client's email was compromised, business email compromised, but her email was personally compromised. And as a result of that, she paid 5 million odd into the wrong account. Okay. She then took ENS all the way to the High Court. It was an appeal to the Supreme Court of Appeal. Luckily, who ruled in favor of ENS, because ENS had taken safeguards about payment. This is a massive risk as well. Are your clients aware of payment methods? Is your business at risk of business email compromise, etc.? That again is another topic for a whole nother day, but just examples of having robust measures in place to safeguard clients' information and money, and of course your own, because liability occurs when there's that breach of that duty on you to safeguard information. And that is why it's worthwhile looking at your organization, and this will come out in a POPI audit. Should I have something like cybersecurity insurance? Does my business need it? Okay. I'm not a financial advisor, so I cannot recommend products, but sometimes you might need to consider whether you need to seek that advice. Okay. So credit agreements need to clearly outline data storage and just general storage, best practices for data protection, encrypt sensitive financial data to prevent breaches. Okay. Use secure cloud with multi-factor authentication. Now, this is where you need to limit data access to only authorized personnel. I'm going through it quickly because I know some of you have other commitments at 11. Clients have the right to refuse consent, but of course this has limitations. This is where someone mentioned the discovery question. That refusal could result in the inability to process the credit application. Okay. Quite similar to that discovery question, I think, unless yeah. So businesses require financial information to assess your credit worthiness. Okay. And of course, naturally in the context of financial institutions or medical aids, etc., which somebody asked now, there is information that they need to process whether you are coverable in terms of their policies. Okay, so what needs to be in a POPI compliant credit application form? Okay, have a clear purpose statement, why it's being collected, how the data will be used, stored, and shared. Okay, you need to have lawful processing. Okay, that it's required to enter into the credit agreement. You need to comply with the National Credit Act. Okay, and do a credit risk assessment for the legitimate interest. And have your statement that the applicant expressly consents to processing where required, and of course, bearing in mind use of third parties. Okay, only essential information. Don't request excessive or unnecessary personal information. Okay, your usual company information. Limited, don't ask for director personal intimate details. Okay, unless of course you are also doing a credit assessment on the director. I'm aware some of you might need your directors to sign surety. Okay, bearing in mind the National Credit Act would apply to that as well as POPI. So only take what is strictly necessary for you to perform your decision on whether you will grant credit to that party. Yes.
So it's actually in the chat, but also touches on your previous slide. It said that due to FIC, they do require ID copies of those directors, and they're struggling to get that information for FIC purposes, but now it also seems like it's, almost contradicting on the POPI side. So, what do they do in that case? Because people are saying, I can't give you my ID copy, it's due to POPI, but then FICA requires them to have that information in order to be FICA compliant.
Yeah. If you are an accountable institution, you cannot conduct business with a party unless you have FICA'd them. So you may not start any business relationship unless you have collected their FICA and identifiable information, such as identity. So unfortunately, you cannot begin a business relationship with that party.
Hope that answers your question.
Sorry?
Yeah, and I'm saying I hope for Tabile that answers.
Yeah, correct. You'll often find that unique institutions are not. Yes.
Good.
Sorry about that. Yeah, I see we are running out of time. So based on that, right? So I'm referring to existing customers. How do we handle that situation?
Okay, with existing, are you an accountable institution? Is that why? Are you asking from that perspective?
Correct. Yeah.
Okay, so as an accountable institution, you've got ongoing due diligence requirements. And you are required to regularly, and it's actually quite funny you're asking this because right now I literally just got an email from my bank asking me to upload my latest FICA, even though, and it says, well, last FICA over a year ago, please do it again. So it's ongoing due diligence. So if you are not, so ongoing due diligence means that you need to do regular updates to check that the information that you have is relevant and up to date. And again, if you've got to terminate that relationship and report it to the FIC if they're unwilling to give it, because it is, to be honest, if you are an accountable institution and you are conducting ongoing business with a party and they refuse to give it, that is generally suspicious.
So okay, so it is a bit of a struggle because it's mostly mostly our key customers. And they just refuse, and they always use POPI Act. I do highlight that FIC does state that if it conflicts with POPI Act, then FIC takes precedence. But it seems like nobody's understanding or maybe not reading the Act. I'm not too sure, but it is
Yeah.
a struggle. So you suggest we just terminate the business?
Well, I'd recommend,
Chandra.
yeah, you'd have to obviously notify them unless you receive the updated information. You are obliged by law to terminate the relationship. Obviously, don't tell them that you're going to have to report to FIC, but something like that you would have to report to FIC if they don't.
Yeah.
Okay.
Okay,
Right.
100%.
I'm going
Thank
to
you.
zoom through for the last minute. So just of course other things in your credit application form. Okay, state how the business will protect personal and company data, outline who has access to it, okay, and it won't be sold or shared. Okay, applicants can request a copy of their data. That's in terms of PIA. Okay, they can correct it, of course, to the extent it's worthwhile highlighting that you recommend that they contact the credit bureau directly in respect of information they wish to object to. Okay, all right, and of course your consent section. All right, things like marketing needs to have opt-in, but you do need a consent checkbox where they need to specifically agree to it. And it's worthwhile also sending them a copy for credit applications of their credit application as soon as they've completed it, okay, subject to the National Credit Act. Okay. And yeah, just again, other things just to quickly mention through, just the gist of what I'm going to end off now. I'm not going to go through the rest of it right now because I think most of the main key points we've discussed, but obviously non-compliance is reputational impact if you're not ensuring adequate safeguards within your business. And the biggest joke I think of last year was probably, if I can say it respectfully, the Department of Justice had a fine of 5 million for security breaches and for not having adequate controls. And I always found it very funny. What was it? The Department of Information, I think. What was it? The Department of Information or something, also a government entity that was responsible for like things like computer and IT. They didn't even have an SSL certificate on their website. And the SSL certificate shows that it's a secure website. So it was quite funny. And then, of course, you've got the Department of Justice getting a fine by the information regulator for failure to have adequate safeguards in place. So it is reputational. And most of those enforcement notices on the information regulator's website did end up on the news. You don't want that to be your business. You don't want to incur damages to clients in case their data is breached or insecure. Employee aspect, don't forget about that. It is, although that wasn't the subject of today, it's all things that you can pick up in a POPI audit. If you need to reach me, I'm going to put my details up on the screen. We do assist with POPI audits, POPI compliance within organizations, privacy policies, PIA manuals, the works. So I would be most happy to assist any of you, but thank you very much to Trade Shield for the opportunity to present. I do hope it was informative. I think if anything from today is that it probably was the beginning of a very thought-provoking exercise as to how you can make your business more compliant, especially with all the individuals and businesses that you work with.
Absolutely. And thank you so much, Natalie. I think we'll be definitely inviting you back as there is so much information to cover in this space. And there are so many questions. So I have also copied and pasted this, your information into the chat should anyone have a question. But more than that, if you wouldn't mind, I'm going to ask you to share your presentation with me or the slides you feel comfortable with for us to then post onto our Knowledge Center. So should somebody wish to refer back to it, we'll then have it there as well.
Thank you very much. I do appreciate it. And I'll definitely share my slides with you. And if you've got any specific requests in future, I would be most happy to.
Perfect. Thank you so much.
The most important thing here is that a lot of times staff hear things and they now got to escalate it. And if they've got it on the slide, they can say, yeah, this is an attorney that is saying this is what we should do. I think we should talk to Natalie and get it closer to us. Thank you very much from our side, Natalie. Thank you guys for listening. I hope it was very helpful.
And thanks very much. And also connect us on LinkedIn. I absolutely love connecting with people. So hopefully I'll see some of you at future events or webinars.
Absolutely. Thank you so much. Thanks,
Okay.
everyone. Have a great day.
Okay, bye-bye.
Bye.
Bye, everyone. Bye-bye.